Hello, my name is Brad Green, and I'm an attorney with the firm of King and Green, and we have offices in Birmingham and in Blount County, Alabama. Today, I wanted to talk to you about guardianship proceedings in the probate courts in Alabama. Now, more specific, I'm going to talk to you about adult guardianship proceedings. And the most common situation that comes up is when someone has an elderly parent or a spouse that does not have an active power of attorney that they've given to someone, and they become incapacitated. Sometimes it might be from some type of medical event like a stroke. Sometimes it can be from more serious diagnoses like dementia and Alzheimer's, but something has happened to render them unable to make decisions about their self and their own health care and to handle their own finances. And so in Alabama, we have a statute that sets out the law for a adult protective proceeding case, such as filing for letters of guardianship and or letters of conservatorship. Guardianship is over the person, the decision about where they're going to live. Do they need certain types of medical care that can be authorized? Examples of what a guardianship covers. A conservatorship is over the finances and the assets of someone. It is most common that if some adult is incapacitated and needed protection, you file to be appointed their guardian and conservator. You can ask for emergency or temporary letters of guardianship and conservatorship. Those are limited to, they can only last for 30 days before you have to have a hearing and further court action in Alabama. And then you have a hearing on permanent letters. And there are specific statutory requirements to be appointed a guardian or conservator. And so it's very important that if you're in a situation like this, that you contact an attorney that you know or that's recommended to you, or you find someone that you see as experienced in this area of the law, because they can give you the best advice about the situation that you're facing. And so this little video is just to let you know that there are remedies out there if you've got a parent, a spouse, or even just a friend that you know that is in a situation where they cannot take care of themselves and they haven't nominated anybody as a power of attorney, and something needs to be done to protect them. You can certainly file these cases in the probate courts in the county where the person is, and there will be a process where a guardian ad litem is appointed for the person that you're alleging to be incapacitated. That guardian ad litem is just a lawyer that the court appoints. Generally, there will be someone called a court representative also appointed. That person most commonly is a social worker that also will be appointed to kind of do an investigation and meet the petitioner and meet the person that's alleged to be incapacitated and provide a report to the court. And there will be a hearing. There has to be a doctor that has treated or examined the person that's alleged to be incapacitated. And if you already have that done, you can get a letter from the doctor. Very few instances where you can just attach a letter from somebody to a petition in an Alabama civil action, but in a guardianship proceeding you can. And that doctor identifies themselves and that they have treated or examined the person that's alleged to be incapacitated, and they say to the court what is going on in that person's life, and if they believe they're unable to make their own medical decisions or personal decisions and or financial decisions. For conservatorship, you also have to be bonded, so you have to post a surety bond, and the court sets that. There are minimum bonds that vary from county to county. Every county has a probate court, and every probate judge can set a minimum bond. And then in the petition, you have to allege how much liquid assets you think they have in personal property value, not real estate, but personal property. And then the judge will affix a bond amount that you have to get bonded and file that. And that bond renews annually, and you have to pay the premiums. So if the court issues letters, the court does have the authority to tax the costs and attorney's fees against the estate of the person who's being protected. That is up to the court after a hearing. So again, there are a lot of different things that could come up in a guardianship proceeding, but I hope this video gives you some idea about where to get started. And if you have a situation like this, I hope the video prompts you to talk with a lawyer that handles this area of the law who can answer the questions that you might have about your specific case. Thank you.